Hello, welcome to the HOME-ARP Rental Compliance Primer webinar. My name is Alex Pereira. I am a Senior Community Development Specialist at ICF. My background is in affordable housing development, but I've been at ICF for about a year and a half. And I'm joined today by my colleague, Les Warner. Les, would you like to introduce yourself?
Sure. Welcome, everybody. I'm Les Warner. I've been working with ICF for 15 years at this point, and prior to that, I, for 20 years, worked at the state level, administering home and other HUD funds, and also did a short stint as a nonprofit developer. Well, I'll hand things back to Alex.
Thank you, Les. So like I said, today's focus is on compliance regarding HOME-ARP rental housing projects. So what we'll cover today in the agenda is, first of all, the responsibilities of the PJ regarding oversight and management of those projects. We'll talk about rental housing targeting, so that's specifically talking about qualifying populations and low-income households. We'll talk about regulations and requirements about around tenant protections and tenant selection. We'll discuss considerations regarding project completion and property standards. We'll discuss the minimum compliance period. And we'll also cover the operating cost assistance reserve towards the end of the presentation. So with that, the learning objectives for today, first of all, is to understand the basic requirements of the HOME-ARP rental housing activity. And I'll say that we also have a webinar recorded on rental housing development for HOME-ARP, which also covers some of those basics. So I'd recommend you check that one out too, if you're interested in learning more about the activity itself. And we also hope that you walk away from today with a good understanding of the responsibilities of a PJ or participating jurisdiction when ensuring the proper monitoring and oversight of HOME-ARP rental housing development projects. So let's talk about the oversight and management then. So when you're looking at a PJ's entire allocation of HOME-ARP funds, it is the responsibility of that PJ to oversee the day-to-day management of those funds. So essentially, the PJ is responsible for making sure that the funds that were allocated to it under HOME-ARP are spent in a manner that is in compliance with the requirements of the HOME-ARP program. Now, when it comes to rental housing projects, there are specific responsibilities that the PJ must observe. And those include making sure that, one, the project complies with occupancy targeting, and we'll talk about that on the next slides a little bit more, that the project complies with the rent and income requirements of HOME-ARP and the tenant protections. Additionally, the PJ must ensure that the project complies with property standards, and that includes ongoing condition standards. So, another way to say this is that once a project is complete, the PJ must ensure that the project meets the property standards and that it also continues to meet those standards throughout the compliance period. So regular checks must be in place for the PJ to determine that. And then we'll talk about operating cost assistance reserves again towards the end of the presentation. But to the extent that a project has those reserves in place, it is the responsibility of the PJ to monitor those reserves, both at the initial capitalization and during the compliance period, to make sure that the reserve is appropriately sized. And lastly, and this is common to other federal funding sources as well, the PJ must determine that the project that it funds is financially viable. Again, both at the beginning of the once the project is funded, and then throughout the compliance period. And it is also the responsibility of the PJ to take action once it identifies problems during those checks. So let's talk about targeting. If you're familiar with HOME-ARP, you may know that HOME-ARP was designed to primarily serve households that follow under one of the 4 qualifying populations, or QPs. we'll talk about those four definitions in the next slide. But under rental housing, there is an additional flexibility that's being provided in that not 100% of HOME-ARP rental units must be occupied by QP units. And I'll kind of explain what that means. So when you're looking at a PJ's entire portfolio of HOME-ARP rental units, not less than 70% of those units must be occupied by populations that meet the definition of a QP, so qualifying households. And we'll refer to those units that are occupied by qualifying households as QP units. So again, under PJ's entire portfolio of HOME-ARP rental units, not less than 70% of those units must be restricted for QP populations, QP households. What that also means then is that not more than 30% or up to 30% of, again, the total of HOME-ARP rental units under PJ's portfolio may be restricted for occupancy by low-income households. And the definition of low-income households follows that that's defined under 24 CFR 92.2. It essentially means households earning no more than 80% of AMI. We'll refer to those units as LI units, so the units that are reserved for occupancy by low-income households. And again, not more than 30% of the total HOME-ARP rental units may be restricted for LI households. And now you've heard me say, units across a PJ's portfolio a couple of times. And the reason I say that is because there is flexibility, from project to project, that the 70% and the 30% thresholds may vary. So you can have one project of HOME-ARP rental housing that has less than 70% of its HOME-ARP rental units restricted for QP households. But once you aggregate all of the HOME-ARP projects, HOME-ARP rental projects that are being funded by a PJ, the sum total of all those HOME-ARP rental units, not less than 70% of those units must be restricted by QP, must be restricted for occupancy by QP households. Excuse me. All right, so quick definition of QP qualifying populations. So the HOME-ARP notice establishes 4 QPs. The first one is the homeless qualifying population, commonly referred to QP1. And that QP follows the definition of homeless under the McKinney-Vento Act that's found at 24 CFR 91.5. If you go to the code, you'll see that there are 4 subparagraphs kind of laying out what the qualifications are. And, any household meeting any one of those subparagraphs meets the definition of homeless under the code. For HOME-ARP purposes, the 4th paragraph in that definition actually applies to QP number 3. So anybody that meets the definition of the 4th subparagraph under the definition of homeless in 24 CFR 91.5 will actually follow under QP 3. QP2 is for those at risk of homelessness. Again, that follows the definition provided for at risk of homelessness under the McKinney-Vento Act that's found in 24 CFR 91.5. And that follows the definition to a letter. No exceptions here, no changes. QP number 3 is for those households that are fleeing or attempting to flee domestic violence, dating violence, sexual assault, stalking, or human trafficking. The definitions here come primarily from the Violence Against Women Act regulation, with the exception of human trafficking. That comes from the Trafficking Victims Protection Act of 2000. And it's worth highlighting here that human trafficking encompasses both labor and sexual trafficking. And once again, this QP number 3 here encompasses that 4th subparagraph of the definition of homeless under the McKinney-Vento Act. And then lastly, we have our 4th QP, termed other populations, where 2 main groups fall under. The first of them is households that have, at some point in the past, been determined to be homeless and are currently receiving some form of temporary or emergency assistance that is keeping them housed, but where the assistance is running out. So, but for this additional HOME-ARP assistance, it's likely that those families or those individuals will fall back into homelessness. So the first group here is folks that, the assistance will prevent that family from becoming homeless. The second group is those at greatest risk of housing instability. That can be defined in a couple different ways. The first of them is folks that are no more than 30% of the area median income, or AMI, and are also facing a severe housing cost burden, meaning that more than 50% of the income is going towards their housing costs. So that's the first kind of way that a household can fall under the second group of QP number 4. Then secondly are those households that are no more than 50% of AMI, but also meet one of the criteria listed under the QP number 2, so at risk of homelessness. So essentially, they're folks that are no more than 50% AMI, but are also at risk of homelessness under the definition of QP number 2. Veterans and families, including a veteran member, don't have their kind of a distinctive QP that they fall under, but as long as they meet the criteria for one of these preceding QPs, then they qualify for rental housing under this program. Now, when we're talking about qualifying for rental housing under this program, that is the eligibility piece of that is determined based solely on whether or not a household meets the definition of a QP. So again, a household is eligible for occupying a QP unit under HOME-ARP based solely on whether or not they meet the definition of a QP. And I'm stressing this because when it comes to determining income for the household, that's really only a few circumstances in which that needs to happen, the income determination needs to happen. But under no circumstance does the eligibility of a QP household hinge on their income determination. So the income determination can never impact a household's eligibility to occupy a QP unit once they have met the definition of QP. So income determination can happen, and that can be in a few instances. First of all, there are some QP definitions that do have income restrictions to them. So income determination will need to happen to determine eligibility under those QPs. Secondly, to determine household contribution to rent. And thirdly, to establish the eligibility of the household for another funding source that may be layered on top of HOME-ARP. So for example, if you have LIHTC funds being added to a HOME-ARP unit, LIHTC brings its own income requirements. So then, the household will need to meet those income requirements. So let's talk about rent requirements now for qualifying households specifically. So for QP units, the HOME-ARP rents cannot exceed the low home rent. The exception to that is if that QP unit receives project-based subsidy, or if the household occupying that unit receives tenant-based subsidy. In those two cases, the contract rent for that unit may be allowed to go over the low home rent to meet whatever the amount is allowable under one of those subsidy programs. This may be new to you because tenant-based subsidy doesn't typically apply in this way under other funding programs, but under HOME-ARP, you are allowed to raise the contract rent to meet tenant-based subsidy rent maximums. Now, if the project consists of SROs, different rent requirements apply. If the SRO includes both sanitary and food prep areas, then the maximum rent is the 0-bedroom fair market rent, or FMR. If the SRO only contains sanitary facilities, then the maximum rent is 75% of that 0-bedroom FMR. It's important to highlight that rent limits here include both the rent and the utility. So we're talking about gross rents here. And for that reason, the PJ must establish maximum allowances for utilities and services and update those utility allowances annually. Although the PJ does have the ability to adopt PHA utility allowance schedules if those are available. So when it comes to contribution to rent and determining that contribution to rent by the tenant, first of all, the PJ must establish policies and procedures that clearly determine a process for determining that reasonable contribution to rent by the tenant. So before you even start looking at, funding HOME-ARP rental housing and monitoring those projects, it's really important that you have those policies and procedures in place to determine, among many things, how that reasonable contribution to rent will be determined. And the contribution to rent by a tenant must always be affordable to the qualifying household based on the income determination that happens throughout the compliance period. So that that amount that the tenant will contribute to rent will be determined each year, starting at initial lease up and then throughout the compliance period based on an income determination. Now, what does that look like? At initial intake and during that first lease up phase, if the household is coming in as a QP that includes an income requirement in its definition, so that's primarily QPs 2 and 4, the PJ should use the income determination that took place when the household's eligibility under the QP definition was being determined to calculate the tenant contribution to rent. Meaning what? Meaning that when that household was going through intake, the income determination had to happen to determine whether or not it was eligible under those QPs that have that income restriction. So since the income determination has already happened, the PJ and the owner don't have to do it again at the initial intake and lease up phase. It can just use that previous determination to calculate the tenant contribution to rent for that household. Now, if a household is coming in under a QP that does not include an income determination, then following the policies and procedures that it has put in place, the PJ should use the information that's been collected at intake to determine a reasonable contribution to rent for that household. Now, after the first, the initial phase of lease up and intake, throughout the compliance period, in each subsequent year, the PJ must examine the income of the household to determine the rent contribution, and that follows the HOME-ARP notice section 6B12.A. I recommend that you read that section closely to understand what the requirements here are. We'll summarize them for you in the slide. First of all, the PJ must use the Part 5 definition of annual income that's found in 24 CFR 5.609. And then when it comes to actually determining the income of the household, the PJ has and the PJ and the owner have 3 options that they can use. First of which is using 2 months of source documentation. So that can be, pay stubs or benefit statements, showing that that household has had a certain income in the previous 2 months. Secondly, you can use self-certification from the household. So that's an income and asset sworn statement that the individual or the family signs, certifying that, yes, this is our income. And then lastly, you have the option of using a written statement from the administrator of a government program under which the household receives benefits and which includes an income determination. So what does that mean? It means that if the household is receiving benefits under a different government program for which the household's income is already being determined, then the PJ and the owner can essentially use that determination for the purposes of determining rent contribution. All you need is a written statement from the administrator of that program. Now, one important thing to highlight here is that for the second option of self-certification, at least every 6th year of affordability period, the PJ and the owner must go back to the source documents. So, self-certification may be the most expedient option here, and it can be used every year during the compliance period, with the exception that every 6th year, the PJ and the owner must be going back to the source documentation to verify that income. Now, if the household, and again, we're talking about QP households here. If the household is not receiving any form of project or tenant-based rental assistance, and based on its income, it cannot contribute any sufficient income towards rent, that will most likely cause a deficit in terms of the operating of the program, because the operating costs are more or less fixed, but the tenant's contribution to rent is because the household is a QP household, it's likely to be a low contribution. In those cases, HOME-ARP allows for operating cost assistance to be in place, to be funded by HOME-ARP. And if there is a reserve that's being funded for that purpose, the project owner may draw from that reserve to cover that gap that's created. Again, if there is no project or tenant-based rental assistance in place and the household's income isn't sufficient to kind of fully contribute towards rent. In addition to capitalizing that reserve, and Les will cover the reserve in more detail later on, but in addition to the reserve, if that reserve is not capitalized at the completion of the project, the PJ can also subsidize rents in the project in a couple different ways. First of all, it can provide ongoing operating cost assistance, sort of on a ongoing basis to cover deficit, the operating deficit of the units restricted for QP households. And again, any form of operating cost assistance, whether that's through the reserve or to the ongoing form, only apply to qualifying households or QP units. And it's worth highlighting here that operating cost assistance, if it's ongoing, it can only go until the end of the program in 2030. So that's something to consider. Past 2030, a PJ is no longer allowed to fund ongoing operating cost assistance. And in addition to that, the PJ may also elect to fund HOME-ARP, tenant-based rental assistance, or supported services, both of which can provide some form of supplement to the household income or help stabilize the household so that it is able to secure a higher income. So if you're considering using one of those other activities to supplement the rental portion of HOME-ARP rental, I highly recommend that you check out the notice requirements and you check out how to exchange for further resources on those programs, on those activities. Now, I've covered this a little bit before, but it's worth rehashing here that the QP units must be occupied by a household that meets the definition of qualifying population at the initial occupancy stage. So once that QP household has been determined at initial lease-up or intake to, indeed meet the definition of a QP, then throughout the compliance period of this project, that QP is eligible to occupy a QP unit. I'm sorry, that household is eligible to occupy a QP unit. This is the most clear when you think about QP number 1. So those are folks that are literally homeless. Once they are housed in a HOME-ARP rental housing project, they're of course no longer homeless and don't technically meet the definition anymore. But that doesn't mean that they're no longer eligible to occupy QP units. As long as they've met that definition of a QP at the initial occupancy, then throughout the life of that project, they can remain housed in a QP unit. And that applies also to changes in household income. So any changes in the household income will not affect its ability to occupy a QP unit and its eligibility to do so. However, at recertification, if the household income is found to be above 50% of the area median income, but at or below 80%, then the owner can increase the contract rent for the household up to the high home rent. And last we'll talk about what happens when a household is found to be over 80% of AMI. But again, in no case does that impact the household's eligibility to occupy a QP unit. So that is all regarding qualifying households. I'll now turn it over to Les, who will talk to you about low-income units.
Great. Thanks, Alex.
Take it away, Les.
All right. So let me just get the slide moving here. All right. So Alex has been talking about, and we kind of have two distinctive categories here on eligibility. We have our QP households, and Alex went through the definitions for those and talked about the implications on eligibility versus determining what an affordable rent is going to be for those households. But I'm kind of switching gears here, and now we're talking about low-income households. So not the QP population, but as Alex mentioned, we could have up to 30% of our HOME-ARP units could be occupied by folks who were qualifying as low-income households. And so you're going to see with this category that, this, for those of you that are familiar with the home program and the rental requirements, you're going to see that these really align with what we're used to doing with the home program. So for those units that are designated, our HOME-ARP units that are designated as our low-income units, those are going to have to be occupied by a household that qualifies as low income. And so in this category, unlike what Alex was talking about with some of the QP households, we're always going to need to be able to determine income eligibility for those households. That's the basis of them being eligible to occupy those units, as opposed to for the QP households where we talked about, formerly homeless or at risk of homelessness, some of these categories that don't require income qualification as part of determining eligibility. So all of our low-income household category, those units, we will always have that income determination in the file to be able to document that they are eligible to occupy that unit. So we're going to follow the home requirements that are at 24 CFR 92-203 in section A1. And we're going to be talking as we go through this section about, we're going to be income qualifying those households at initial occupancy. And then throughout the affordability period, we're then going to be going back doing an annual recertification. And in the case where their income goes up, we may be making adjustments to the rent for that unit. We're not going to say, oh, now you're over income and you're going to have to move out of this unit, but we'll be talking about the monitoring of those units over that affordability period and the required actions that you would need to take as you go along. And these, again, these follow the home requirements, our regular home requirements, just like you may be familiar with your other projects. So when we see that there is a tenant's income at recertification that has gone over income, so over that 80% area median income, we may, depending on whether we're able to make adjustments on that, we may have a project that's temporarily non-compliant because they're waiting for that opportunity to bring that unit back into compliance. That's fine. The issue here is the PJ understanding what are the requirements, and am I monitoring appropriately to make sure that when I have the opportunity to bring this back into compliance, that I'm doing that. So for instance, if I have a tenant that goes over income, let's say goes over 80% area median income, we're going to be going through the details in a minute or so on this, but we would take action to adjust their rent, but we're not going to require them to move out of that unit. So temporarily, we're going to have one of our low income designated units that's going to be occupied by a household that actually isn't low income. Their income has risen since their original eligibility was determined and they were allowed to move into that unit. So the PJ needs to be, as they are re-verifying income on an annual basis and tracking rents, they would be then taking appropriate action. So if that tenant that is over income maybe in a year or two decides that they're going to move out of that unit, maybe they're moving to a different area or they can afford a market rate unit and they're choosing to move somewhere else, when we go to re-rent that unit, then we're going to make sure that we rent it to an income eligible household. We're going to charge them the appropriate rent for our low income households on this HOME-ARP project, and that would bring that project back into compliance. We'll talk through the details of that a little bit more as we go forward here. So our requirements about the rents that can be charged. So we always have this is our household income eligible as one of our tests, and then setting what's going to be an affordable rent. So for our low income households, or those designated units, we're going to be tracking to make sure that that rent doesn't exceed that high home rent limit. Now keep in mind that high home rent limit is includes not only the tenant paid rent, what I might call a lease rent, but it also includes any utilities that that household themselves is paying. So if we've got a tenant paying, I don't know, $800 a month in rent, plus they have, according to our utility schedule, they're paying approximately $100 a month in, let's say, electric for that unit, then that's $900, and we would have to compare that to our high home rent limit and make sure that that was going to be in compliance. The exception to this is when we have a tenant-based subsidy that contract allows to go above the high home rent limit, and then again, that's going to be capped at what we call the contract rent. So whatever that tenant-based subsidy limit is, would be the maximum, because in this case, we might be exceeding the high home rent limit, but that tenant is only paying that affordable rent that's been set for them. That subsidy is paying the balance. And that's why we have this exception to allow them to exceed the high home rent, because it does not have an impact on the affordability for that individual tenant. They're still paying that affordable rent. As Alex mentioned, when we look at our rent schedules for the home program, we have that also then broken out depending on the type of unit. So our unit rents are set by number of bedrooms. So if we've got a 3-bedroom unit, we're going to look to the chart to see what the high home rent is for a 3-bedroom unit in your community, and that's that maximum rent and utilities that the tenant is paying that you're going to need to make sure you're in compliance with. But if we have some other types of units, such as if we have a single room occupancy, that's what an SRO is, then the maximum rent is not going to be the same as a 1-bedroom unit. It's going to be based on the kind of facilities that that single room occupancy unit has access to. And this is similar, this is the same as what Alex talked about earlier, that if we've got this 0-bedroom unit that has both sanitary and food prep as part of dedicated to that unit, then we're going to charge our 0-bedroom fair market rent is going to be the maximum rent for that unit. But we also will have single room occupancy units that maybe they have their own bathroom, but they're sharing a kitchen, or maybe they have cooking facilities in their room, but the bathroom is down the hall. So we're not going to charge them that full 0-bedroom fair market rent, because their unit's not really comparable to that. It doesn't have that both sanitary and food prep facilities. So in that case, we're gonna look to a reduced maximum rent, and we're gonna use 75% of the 0-bedroom fair market rent, and that's gonna be our maximum rent that can be charged on that. So, you know, if I'm a property manager for a project that includes HOME-ARP funds, I'm going to need to know which of these units are designated for my qualifying populations, and know, okay, these are the rules that will apply on who's eligible, how we set rents for this. For my low-income households, I'm going to be following my high home rent limits, except where we have single room occupancy units. And then we're going to be looking at the fair market rent for 0-bedroom units. And then depending on whether they have both sanitary and food prep, charging that full amount as our maximum, or using only 75% if we don't have both food and sanitary. All right, so let's talk a little bit about what happens with over income households. So key here is that everyone needs to be determined to be eligible at the time that they first move into the unit. So following the protocol for eligibility for the QP households, it might be based on the fact that they are currently homeless or at risk of homelessness if it weren't for some kind of short-term subsidy that they have in place. Others, we've actually done an income qualification on this. So we always need to make sure that that household is eligible when they initially occupy that unit. But we're also then going to be recertifying their income on an annual basis. And based on that, we're going to see changes in income over time. I mean, really, hopefully, we would see that our households are going to, over time, see their income rise and at some point not need the subsidized unit that they're residing in, and probably move on to other units, other places where they choose to reside because now they have more choices. But for over income households, so when we do a recertification and we determine that they have gone over 50% of the area median income, then we're going to make an adjustment on their rent. So Alex mentioned that our QP households, our maximum rent is the 50%, the low home rent. When these households at recertification are found to go over 50% area median income, we are going to then make an adjustment in their rent, and we're going to change that rent level to the high home rent. So that's based on what's going to be affordable for a household that's between 50% and 80% of area median income. And if you're not familiar with high and low home rents, want you to know that that's something that is published on an annual basis by home. So it's not something that you need to try to figure out and calculate. Those would be published. They would be available on the HOME-ARP website. If you were a developer or an owner, that's something that the PJ, each time those new rent schedules are published, are going to be sending out to you. So that's for our QP households. If they go over 50% area median income, we're going to bump up their rent from that low home rent to the high home rents. For the sector of our occupants that are not QP households, but are our low income households, then we're going to have a separate criteria on this. So for our, and when we're determining that they were low income at initial occupancy and then their income goes over 80%, then we're going to be following our income adjustments based on the home regs at 92-252 item 2. And so this is what you're familiar with regular home, that we are going to be recertifying their income. We could be doing our full certification with 2 months of source documentation, or we could be accepting another program that was finding them eligible. But we're going to be adjusting their rent when they go over 80% AMI. We're going to be adjusting their rent to 30% of those household income. And we might have some local or state laws that put some further restrictions on that. So we're not going to require that household. Let's say my household, when they initially occupied, moved into that unit, we did their initial income certification, they were at 60% AMI. We go back and we're doing annual income certification. Maybe in year 2, we find that they've been able to get better jobs and now their income is at 90% area median income. So they're considered over income at this point. And so we're not going to require them to move from the property, but we are going to make that adjustment. So we are going to then calculate what 30% of that family's adjusted income would be. So this is one of the instances where using adjusted income comes into play rather than simply taking 30% of the gross income for this. And so we're going to raise that rent for them. So they're going to be paying something closer to what a market rent would be. In the case where we have our HOME-ARP units that are in combination with low-income housing tax credit units, LIHTC units as they're often called, then the rent that's going to be charged is going to be in accordance with the LIHTC rules. And so the LIHTC rules don't actually make a change until their income goes higher. So just know that if you have ARP units that are in combination, that unit itself has also been designated as a LIHTC unit. We're going to defer to the LIHTC requirements about when we make adjustments on rent. For a floating home unit, so we haven't really introduced this concept of fixed and floating. When you are funding these units, you are designating not only these are my QP units, these are my low income units, and keeping in line with that 70% overall for your portfolio, maximum of 30% for low income. But you also, as the PJ, would be making a decision about, are we going to make these fixed or floating? So if we make them fixed, we're designating specific units that are going to be my QP units, that are going to be my low income units. And so over the life of that project, compliance will be met based on those specific units and the terms and conditions that would apply to them based on the designation I've made. You do have the flexibility of designating them as floating home units. What that means is, so if I have, let's say I have 6 low-income units in my property, and I designate those as floating, and maybe my property, let's just for simplicity say that all of my units are 2-bedroom units. Throughout the life of that project, you would need to have 6 2-bedroom units that are occupied by low-income households, or if they're over, if they've after initial occupancy have their rent has gone or their income has gone over 80%, that you are following that protocol. But over time, the specific home units could be different over time. So if we have a household that's gone over income, we might be able to replace that unit with another 2-bedroom unit that becomes available, and then designate that as our HOME-ARP unit that's going to be occupied by a low-income individual. So just keep in mind all the rules that if you've worked with the home program and rental that you're familiar with, these are going to also apply for your low-income units, and the actions that you would be taking as you recertify and find that incomes have gone up or down. So let's talk a little bit about the tenant protections that are in place for our HOME-ARP units. So for those of you that have worked with the HOME program before, you know there are a list of prohibited lease provisions. Those are found at 24 CFR 92-253 item B. And essentially those prohibited lease terms are prohibiting anything that's going to require that tenant to waive some of their legal rights. And so either you would, as the PJ, need to be reviewing the leases that are going to be used for your HOME-ARP units and making sure that those leases did not contain any of those prohibited lease provisions. Another option would be the PJ itself could have a standard lease that you provided and said, okay, for all of our HOME-ARP units, you're going to need to use this lease. Or really the third option here is that, which I think a lot of people use, is that they have essentially an addendum that gets attached to whatever lease folks are using. And it essentially says, this attached addendum, if any of these prohibited lease provisions are included in the lease, that with this addendum, it's going to make those null and void. So that's one of the requirements under tenant protections, to make sure that none of these prohibited lease provisions that are listed out at 92-253B have been put in place for any of our HOME-ARP tenants. Also need to make sure that you cannot terminate or refuse to renew a lease for those HOME-ARP units, except for being able to document that there are serious or repeated violations of those lease terms and conditions. Keep in mind, you probably have an overlay of federal, state, and local laws that also would have an implication as part of this. Also, we cannot either terminate or refuse to renew a lease where we have qualifying households that simply don't have earn enough income to be able to pay that rent during the compliance period. So Alex talked earlier about the flexibility that our projects have. In the case where we have a household that does not have some kind of a project-based or tenant-based rental assistance that's going to make that unit affordable for them, HOME-ARP does allow us to dedicate or use HOME-ARP funds to provide operating cost assistance. And so that could be funding that's going to the project to cover that shortfall for these households, or our HOME-ARP funds could have been used to set up an operating cost reserve. And so we can't determine, well, we've got a household that we're having to use these reserves or this operating cost assistance, so let's just not renew their lease so we can save money. You're not able to do that. That's why we have operating cost assistance and operating reserve eligibility under the HOME-ARP program, to make sure that we can continue to serve this targeted population who's really challenged in being able to find decent, affordable housing. If the project, so in the case where we have a tenant that what's affordable for them does not cover the required rent, then we would be calling upon that operating reserve or our operating cost assistance to be able to pay that gap for that. In cases where we have a project that does not have operating cost assistance, or maybe that has lapsed at some point during the life of that project, the PJ could use tenant-based rental assistance or other short-term financial assistance under supportive services to make sure that that unit would continue to be affordable for that particular household. But we are not going to choose not to renew their lease. So one of the flexibilities that is something that is different under the HOME-ARP program versus the regular home program is that generally under home itself, we would say that we always have to have that lease between the income eligible tenant and the PJ or the project owner. One flexibility we have under HOME-ARP is to allow for a master lease or a sponsor to have a lease for a number of units and then be subleasing them to qualifying households. And this is something we oftentimes see with our homeless programs or continuum of care, where we might have a nonprofit that's going to hold a master lease for a number of units. Then they're going to work with identifying qualifying households, and then they will sublease those units to each of those individual households. So our exception under HOME-ARP is that when that sponsor is a nonprofit that's providing housing or supportive services, they're then going to take on the responsibility of qualifying households, facilitating those subleases for those units. And again, this is only applicable to units that are occupied by our QP, our qualifying households as part of that project. And so we'll have a master lease for the nonprofit. And then, as I mentioned, that sponsor will then have a sublease for each of those qualifying households. And of course, we're going to have documentation, a paper trail to show that with that master lease, that then they have identified and executed appropriate subleases for those households, being able to document that they are eligible, that they are paying an appropriate rent, that are restrictions about, protecting them from lease provisions, other things, that those are all being followed as part of that sublease that's being done by our HOME-ARP sponsor. Let's talk a little bit about tenant selection. So we sort of may have two different paths here. So for qualifying households, these are going to be designated on a project by project basis. This is something that the PJ would be reviewing and determining what that tenant selection and probably marketing outreach process would be. You could be pairing with your continuum of care's coordinated entry process. But you could also be doing your coordinated entry in combination with other referral sources. So you may have other providers working in the area that are trying to serve households that would be qualifying households that would also be working in conjunction with that. Your third option is to have a project-specific wait list. So that's something as part of the funding decision that the PJ would be reviewing and determining what that process would be. That would then be included in that written agreement. So designated what's the tenant selection process that's going to be followed over the life of that project. If there are preferences that are being used on determining with the qualifying households, how do we determine, who gets priority in this? Those would need to be identified and disclosed as part of your allocation plan, and that would be incorporated then into your tenant selection criteria that are going to be used as part of that. So that's for our qualifying households. For our low-income households, they would be using a project-specific wait list and then following that process to determine who was going to be eligible to occupy that next available unit. And again, those are going to be things that are transparent so that each household is being treated in the same way equitably for that, determining with those limited number of units that we're following a standardized process to determine who's going to get the next available unit. So as part of this, the project owner is going to need to adopt and follow that written tenant policy and criteria. And so thinking about, we talked about these restrictions on the designated number of units that have been set aside for qualifying populations versus low-income households. So that becomes part of that tenant selection process and determining, okay, for this, let's say we have a unit, we've had turnover and we have a unit that becomes available, determining, okay, is this ineligible that I need to rent this to a qualifying household? Or is this one of my low income units? And that'll determine who's eligible to occupy that unit, what the rents would be that could be charged for that. You also need to be following any PJ preferences that were established as part of your allocation plan. And of course, not implementing any discriminatory requirements as part of that. We sometimes see projects that want to say, well, I'm going to exclude an applicant that has a Section 8 voucher, and that's something that's not allowable. And that would also include somebody that has that's participating in a tenant-based rental assistance program that might be through HOME or HOME-ARP or some other federal program. Keep in mind that the requirements under VAWA, which is protecting rights of folks who have been victims to abuse or dating, violence, and there's a list of criteria on this. We need to make sure that the VAWA requirements are also included in your tenant selection criteria. That would be something that's already standardly required for your home projects, and each PJ would have that criteria in place already. And so we may need to be communicating with property managers for HOME-ARP projects who might not be familiar with VAWA, that's also going to be a requirement. And then making sure that we give a prompt notification for anyone that's being rejected on their application, that we not only give them a prompt decision on that, but we also, that notification would include information to be clear about what was the reason for their application being rejected, and obviously it needs to be in line with your tenant selection policies and criteria that have been laid out. And keep in mind then we talked about for our low income households, using a project specific wait list. Some of our qualifying population may also be using that. We need to make sure that they are following that chronological order. And keep in mind, you may have some prioritization that's been built into it, but you'll be following that tenant selection criteria. It'd be very clear how you decided who that next tenant was going to be based on your established wait list and the criteria that goes with that. So we have some rules about not only how quickly that project is up and running and occupied, but then also about the term, the affordability period for this that we're going to talk about. So our HOME-ARP rental projects need to be completed within 4 years of project commitment. So that written agreement is going to call out, usually it's going to include a timeline that's expected for that, which probably was part of the application when it was submitted for funding. But our maximum here is 4 years within for project completion. And when we talk about how do we define project completion, means that all construction has been completed, any title transfer requirements that would be part of that project have been completed, but that project now meets all of the property standards. So we probably have an overlay of local, maybe state property standards, but also your HOME-ARP requirements. So all of those have been met, and the final drawdown for the capital funds for this project have been dispersed. At that point, we would consider that project to be completed. So we need all of that to happen within that 4-year time frame. I would think that most folks are going to set their project completion deadline probably something lesser than that 4-year maximum that is set by the HOME-ARP program, so that if there are any bumps in the road, that you could work with that project and make sure that you actually meet the 4-year maximum that's in place for HOME-ARP. We also are concerned not only about getting the project completed, but this is a housing production program. We need to make sure that those units are occupied. So for HOME-ARP, and this should sound very familiar to those of you that are already working with home rental, we need to see that those units within 6 months of completion are occupied by either qualifying or low-income households. So we could have a project that had a mix of HOME-ARP units and maybe tax credit units. This rule is going to apply specifically to our HOME-ARP units. So we need within 6 months to be able to show that they've been occupied. At the 6-month mark, essentially, HUD may be looking to see if they're not occupied at this point and asking the PJ, tell me about your marketing efforts, tell me how you are going to ensure that within our 12-month timeline, that all of those units would be occupied by eligible households. If the PJ fails to be able to show that those units at that 12 months after project completion have been occupied by eligible households, then those HOME-ARP funds would need to be repaid. So obviously we want to make sure that the units that we have funded with HOME-ARP, that we're confident that we have a population that needs these units, that we're doing appropriate marketing and outreach to make sure that we get those units occupied. But also, oftentimes the challenge here is for the PJ, making sure that the reporting coming back from that property owner, that is coming back to the PJ in a timely manner, and it's also getting reported into IDIS on this. So make sure that you're tracking your projects and that you know what the status is on this. You want, as the PJ, to know that, if we are approaching that 6-month timeline and we're not seeing occupancy on this, the PJ is going to want to be a little proactive on asking questions, ensuring that there's not going to be a problem in meeting that deadline. All right, so let's talk a little bit about property standards. So as we're familiar with the HOME program, each of our assisted projects are going to have to meet property standards based on the type of project they are. These are found at 92-251. And so we have specific requirements for new construction. We have separate requirements for rehabilitation. We have requirements specifically to acquisition of standard housing and the documentation that would need to be in place on that. Manufactured housing is something that's eligible under the HOME program. And so that also, we have a separate set of standards that would apply. Keep in mind, you probably have an overlay of state and local property standards that would also apply to this. So we're talking about, as those units are completed and going to be placed in use, that we have standards based on the type of project that they are included in. But you'll see our last bullet point then is about ongoing property standards. And you'll find that in the same at 92-251 under Part F. So we have a standard for at project completion, and then we have a separate standard for throughout the affordability period for that project. So let's talk a little bit about that affordability period, that minimum compliance period, and what the rules are going to be for HOME-ARP. So HOME-ARP rules are a little different than what we have under the HOME program itself. So this is set up as a minimum of a 15-year compliance period. And that's, it doesn't really matter about the type of assistance that's being provided with your HOME-ARP or the type of activity, whether it's new construction or rehab on that. So all HOME-ARP projects are going to have a 15-year compliance period as a minimum. Now, the PJ has the ability to choose to impose a longer compliance period, but keep in mind that under the HOME-ARP rules, you will not have access to being able to provide additional operating cost assistance to cover those shortfalls during an extended compliance period. Now, I would anticipate that a lot of our HOME-ARP projects, instead of perhaps using operating cost assistance, have project-based rental assistance payments in place. And so in that case, that compliance period is going to be the greater of either that 15 years that's a minimum for HOME-ARP, or if we have a HAP contract, let's say it's for 20 years, then our compliance period is going to be set at the greater of those two, so it'll be 20 years for that project. During that time period, we need to make sure that that project will continue to serve the population that's been designated to continue to be affordable. So we need a way to be able to impose those restrictions, something more than just a lien position or a mortgage on that property. And so you will be required to have a deed restriction or a land covenant that would be in place. It would be recorded, and that would be a mechanism that then would be used to enforce that affordability period. If you have an alternative mechanism that you want to use, it would need to be reviewed and approved by HUD before you would be able to use that. So this is pretty standard for what we do under the home rental program. Similarly, you would see deed restrictions, land covenants being used for low-income housing tax credit projects. And essentially what this is doing is that if the property owner were to choose to sell that property during that affordability period, that transaction would be restricted by this deed restriction or land covenant and that would transfer those restrictions onto the new owner of that property. And we're going to be talking about, if we fail to impose this compliance period, what's going to be happening on that. So this is important for the PJ to ensure that we're going to meet this minimum compliance period to ensure that there's no money that has to be paid back on this. So let's talk a little bit about those penalties. So if we have a project that is terminated prior to completion of the project itself or fails to continue to meet all the program requirements and serve as affordable housing based on those terms during that compliance period, the PJ would be required to pay funding back. Now we have a little bit of relief on this for the HOME-ARP program. So depending on when that non-compliance happens, if we complete a project, place these units in service, and we have completed 10 years of that compliance period, for that first 10 years, we're going to have to pay back 100% of the HOME-ARP investment if that project then fails to continue as meeting the compliance period requirements. But if our project completes a full 10 years and is now in year 11 through 15, if that project was in non-compliance for failure to meet those ongoing requirements, then we do have this proration that is allowed, which is something we don't have within the regular home program. So once we are in year 11 through 15 on our compliance period, the amount that would be required to be repaid is going to be reduced on a pro rata basis. So 20% will be essentially forgiven for each year that that project has completed beyond that initial 10 years on that. So of course, our goal here is to make really sure as we fund projects, as we establish either project-based subsidies, or we have operating cost assistance, or we have funding in place to cover those deficits. We want to make sure on the front end that we are confident that our project is going to be sustainable throughout this period, that we don't really have a question about non-compliance and having money be paid back. But there is a little bit of flexibility after year 10 of the compliance period. One of the ways that we would not have repayment be required would be when that property actually transfers to another owner and these restrictions are going to flow to that new owner. So we talked about having deed restrictions or a land covenant in place that would apply and stay with that property. So if we have a property owner that sells that property either voluntarily, or let's say it goes through foreclosure and the deed restriction is not removed as part of the foreclosure process, then we have restrictions in place that would require that subsequent owner to follow these requirements. So those HOME-ARP restrictions that we imposed with this deed restriction or land covenant are being followed. The new owner is complying with that, and that would be throughout our duration of the compliance period. Also, we need to make sure that those HOME-ARP funds that are set aside for operating cost assistance, either in a reserve or direct funding, that they are staying with that property that they conveyed with the sale or transfer of that property. So if that property actually is sold, but they continue to be in compliance, then they would not be required to make that repayment. And that's part of the reason that we're filing our deed restrictions or land covenants to try to make sure that we avoid that. So as you can see, there is a risk for the PJ throughout that compliance period for the project. So the PJ really needs to have some systems in place, sort of a schedule, and be thinking through how are we going to provide enough oversight to make sure that these projects continue to be viable, they continue to serve the population, that they are meeting those requirements. So one of the things that we need to do because of our targeting on this, making sure that our projects remain financially stable, is really overseeing the operating cost assistance reserves on this. So if you've established operating cost reserves for that project, which is something that's allowable under HOME-ARP, we need to make sure that those reserves are being held in an interest-bearing account. So we want to make sure that they are growing and generating a little bit of income as they are sitting there. But we also need to make sure that they are being kind of restricted on when those funds are being drawn. So the property owner is required to submit a written request to the PJ prior to the disbursement. So the PJ is determining, is there a shortfall? Is this an eligible cost? And we'll be approving that before funds are being drawn from that operating cost reserve. So the PJ is determining, is it reasonable? Is it necessary? And then, approving or denying that requirement. Also with this, not less than annually, the PJ needs to be reviewing those reserve accounts to make sure that the funds are there, that they continue to be an adequate remaining balance to cover the projected potential deficits that project would be experiencing. So we may have set up our project reserves. They're going to be based on projections we've made about, how often we think there's going to be a draw that needs to be made from that. Depending on the actual income of the mix of tenants in that project, we might see those draws be faster or slower than what your initial underwriting had determined. So that PJ needs to be at least annually looking at those project reserves, getting reporting on that to determine, are we still okay? Or do we need to think about interceding in some way to be able to stabilize that project to ensure that it's still going to be sustainable throughout that affordability period? And our goal here is, as early as possible, if there are any red flags, we want to identify those and have as much time as possible to be able to then take action to prevent some kind of failure and non-compliance for that project. So for our projects that have completed their compliance period and we still have funds that are remaining, those funds that are remaining in that operating reserve would need to be returned if that project is not going to continue to operate as a HOME-ARP project and continuing to be serving that population beyond the 15-year period. And so there would need to be a closeout process for the PJ to determine, yes, we've completed that affordability period, but also we need to look at that operating cost assistance. Are there funds in those reserves? Do they need to be returned as part of that? Is this project going to continue to operate for some period of time? And so could those funds be allowed to remain? So if those funds are returned, they would be deposited in the PJ's local home account. They'd be recorded as program income in IDIS, and so they would need to follow then the regular rules for home program income. We're going to be expending them on another home eligible activity. All of the rules, the other federal requirements are going to apply to that. So projects could retain funds in their operating reserve if that project continues to operate as a HOME-ARP requirement. They're going to be able to show that, yes, we are following all the HOME-ARP restrictions and we're continuing to serve qualifying households. any additional operating cost assistance, cannot be provided after September 30th of 2030. And so that's really our hard and fast deadline on being able to add any funds to those projects. All right, so we're going to close this with pointing out some resources for you. And I would guess that we've got a mix of folks that are part of this webinar. Some folks probably have extensive experience with home and are learning just the specifics about HOME-ARP funding and how that might be different and how you might need to adapt your system. But we also may have folks that are not only learning the basics of HOME-ARP, but also aren't familiar with some of the home terms that we're talking about. So there's some very good resources that are continuing to build over time. So on the HUD Exchange, and we've provided the this first link, is for a frequently asked questions link. So this is being built out over time as we have PJs and other partners beginning to work with the HOME-ARP funding. We are having new questions that are asked, and as answers are being developed, those are being posted here. So I think that's something to revisit from time to time as new clarifying guidance is being provided. There also is a HOME-ARP specific landing page on the HUD Exchange, and that's our second link here. So kind of everything HOME-ARP, that's our go-to source, and there will be a lot of resources on that page, including links to training such as this training that we're in today, but also, as Alex mentioned, there's a companion piece that was done earlier on HOME-ARP development that would be, if you missed that, would be a good one to also participate in. There's a rental housing, HOME-ARP rental housing fact sheet that I think would be helpful for folks. And then there's a whole resource on setting up preferences and referral systems, which we talked about on that tenant selection criteria that would be important. There is a HOME-ARP underwriting tool that's in development, so I'm hoping that we'll see that soon. And I would just add to this list. So, we've introduced in today's session, mentioning things like fixed and floating and all the regular home rules. There is the e-building home online home training and a whole other, a whole nother menu of home trainings that go to some of these rental operating and compliance items that I think would be applicable for your HOME-ARP. So for a deeper dive on some of those, you might also turn to some of the home resources on that. So with that, I think we're going to close out. Alex, anything you want to add before we close our webinar?
No, that is all. Thank you all for watching, and hope you found it helpful.
Great. Thanks, everybody. See you soon.